And the gentleman from Washington's a kind person as well, and she is now recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report. Gentleman from Florida reserves point of order.
Amendment to the
Without
amendment.
objection, the amendment will be considered as read. The gentlelady from Washington is recognized to explain her amendment.
Thank you, Mr. Chairman. What happened to Sarah Root is a tragedy, and as a mother, my heart aches for her family. No parent should ever have to go through the unbearable pain of having to bury their child. Sadly, passing this legislation would not bring Sarah's killer to justice. Sarah's family was failed by the government on multiple levels, and in fact, I know that they've been going after the local judge in this particular case. Fundamentally, this is a problem best solved at the local level, where they are better equipped to avoid unintended consequences. Unfortunately, the legislation before us today is an imprecise federal bill that would make a massive change to the national immigration system. This sort of bill acts a bit like a sledgehammer, hammering away at the problem, but causing an enormous amount of damage in its wake. Through this bill's extraordinary breadth, it will put large numbers of people, including DACA recipients and TPS holders, at risk of being subject to mandatory detention, even if they are innocent of the crimes of which they are accused. Like all of the immigration enforcement bills we have marked up so far in this Congress, this bill does absolutely nothing to fix the immigration system, and it has zero chance of becoming law. On the day before the government is set to shut down, this is not how we should be spending our time. We should perhaps be discussing the recent Congressional Budget Office's assessment that over the next 10 years, immigration is going to grow the economy by $7 trillion and increase revenue by $1 trillion. We could discuss how a new government study shows that refugees and asylees have a net positive impact of $124 billion over 10 years. But no, instead we're taking up legislation that has no chance of becoming law, does nothing to fix the system, and demonizes immigrants and immigration. The amendment I'm offering today would address some of the very broad consequences of this bill. Under the current version, someone can be subject to mandatory immigration detention simply for being arrested or charged with a crime that led to serious bodily injury or death. But as we have discussed in the previous bills that we've discussed in this committee, people are mistakenly arrested and charged with crimes far too often in this country. Do we really think that it makes sense to subject them to mandatory detention, even if they were wrongly arrested and then exonerated? A mistaken arrest can be a huge burden on an innocent person. Just look at what happened last year in Kenosha, Wisconsin. An African-American couple was eating dinner at an Applebee's with their 1-year-old son when the police came in looking for a couple who had just committed a hit and run. While the actual perpetrators hid in the restroom, the police violently arrested the innocent couple even while the father was holding the child in his arms. It took half a year in court to get the charges against this couple dropped, but the psychological and emotional scars from that, I'm sure, still remain. If this couple had been DACA or TPS recipients, and this bill was the law of the land, they might be in immigration detention now, even 2 months after they were exonerated. My amendment would also require that there be a conviction before the mandatory notification requirement under this bill takes effect. Releasing this type of personal information to a victim's family based on a mere charge is extremely dangerous, and it is not something we should be doing. Last month, we unanimously moved Mr. Massey's bill, H.R. 6824, out of committee. That bill is aimed at identifying and preventing the negative consequences of racially biased misidentifications in the gun background check system. I don't understand why we would want to move forward with a bill today that would amplify those same negative consequences in the immigration system. We passed Mr. Massey's bill in a bipartisan manner, and I hope that my colleagues are willing to work with us on this legislation as well. Unfortunately, without my amendment, the bill before us today has significant unintended consequences, and I would not be able to support it. I urge my colleagues to accept my amendment, and I yield back the balance of my time.
The gentlelady yields back. Is there further discussion on the amendment? Gentleman withdraws his point of order. I'll recognize myself for 5 minutes. I would just remind my friend that Laken Riley's accused killer was never convicted of a prior crime. He was arrested and released by New York authorities. Arrested and released. Arrested and released. That's the Democrats' favorite pastime in our cities that they control, and it's a principal cause of the carnage which those cities are now suffering, and whose constituents are now starting to awaken to the damage of these foolish policies. We've been through this discussion many times before on similar bills, but since the gentlelady wishes to make her points again, I'll make my points again as well. I wish for a change that the Democrats would be just as concerned with the rights of Americans as they are with the rights of illegal aliens and the crimes that they're committing in our communities. But let's just call this out real quick. Under current law, an alien already can be subject to mandatory detention without a conviction. We've gone through these examples many times, but somehow they just don't sink in. An illegal alien who admits to committing a crime involving moral turpitude, or who admits to committing a controlled substance offense. Any alien, including a green card holder who commits a drug offense. All of these are subject to mandatory detention under current law. In 2019, the Supreme Court noted the expansive nature of mandatory detention. They highlighted that part of the reason for mandatory detention is to reach aliens who necessarily escape conviction, and another part sweeps in aliens for whom there is no reason to expect police, as opposed to immigration officials, will have reason to arrest. That's why we have these provisions in law. Under current law, even the spouses and children of certain illegal aliens must be detained if the DHS secretary knows or has reason to believe that a spouse or parent trafficked drugs and the family members knowingly received a benefit, financial or otherwise, from that activity. So if it's the breadth of this policy that the Democrats are concerned about, it certainly sounds like they'd like to strike down the entire mandatory
would the gentleman
detention
yield?
section. No, not till I'm done. So again, your objection is the entire mandatory detention section, which already has been the law of the land.
That's why I was asking if you
applied
yield.
to aliens for decades. Sarah's law makes so much sense that I think Americans would be surprised to know that it's not already the law of the land. This amendment would strike this provision, and let me.
Would the gentleman yield? I just want to clarify something,
Let
Mr.
me
Chairman.
let me raise one other set of points first. We keep hearing that these are illegal aliens who will be wrongly detained. But here's the reality. Aliens who are inadmissible for being in the U.S. illegally or lacking valid documents should have been detained once they crossed the border in the first place. And they should have been continued in detention throughout their immigration proceedings. That is the current law. And aliens who've had their visas revoked or failed to comply with their non-immigrant status no longer have a basis to remain in the United States. To even lodge a detainer against an alien or to arrest an alien in the first place, DHS has to have probable cause that the alien is removable from the United States. Once detained, if an alien claims he's wrongly subject to mandatory detention, he can request review before an immigration judge, who will then determine whether the alien is in fact an alien, whether he fits within the category of mandatory detention, and whether DHS is substantially unlikely to establish that the alien is subject to mandatory detention. All those rights are in existing law, and all of those rights apply in this case. And that detention is far from indefinite. According to data from the Executive Office for Immigration Review, the median case completion time for an alien in detention was only 42 days in fiscal year 2033. Yet if the alien is truly innocent and wrongly detained, as the Democrats argue, then the alien can quickly receive asylum and be released. If the Democrats cared about public safety and the constituents they serve, I think they would reject the amendment and they would support this bill. But that doesn't seem to be the case, and I'll be happy to yield to the gentlelady for my remaining time.
I may need a little bit more time, but I just wanted to be very clear about something. I am granting that if somebody is convicted of or admits having committed or admits committing acts which constitute the essential elements, of any offense that resulted in the death or serious bodily injury. I'm not touching that, Mr. Chairman. My amendment does not do anything with that.
Reclaiming my time. You should at
Well, I
least
think your
understand
time
that
is
that
over, so
person,
I'm gonna-
that person.
I think your time is expired.
That person is subject to detention anyway because they've committed the crime of illegally crossing the
you're-
border.
I think
Further discussion
Process point here, Mr. Chairman, I think your time is over.
by 10 seconds. It was by 10 seconds.
I know, but
You
I-
interrupted me, but I'll be happy to recognize Ms. Scanlon now.
Thank you, and I yield to the gentlewoman from Washington.
Thank you. Again, I just wanted to make it clear that it is the case right now that if you're convicted of, or admit to having convicted, or admit committing acts which constitute the essential elements of any offense that resulted in the death or serious bodily injury, you are subject to mandatory detention. What this bill does, though, it expands that dramatically. And it says if you are charged with or arrested for, and that is the problem that I have. That is why I am submitting my amendment, because I am saying just being charged with or being arrested for a crime does not mean that you should suddenly give up all your due process rights and be mandatorily detained. So I am saying, yes, I understand what the law says right now, but this bill is a dramatic over-expansion, and it fundamentally hurts due process rights. And frankly, it's extremely dangerous, because if somebody is just charged with a crime or is just arrested for a crime, you're essentially saying that from that point on, they have to be mandatorily detained. Not only has no administration ever been able to mandatorily detain everybody that is subject to mandatory detention right now, that's true of Republicans and Democratic administrations. But now what you're saying is we're going to expand that population even more, and we're going to mandatorily detain or require to mandatorily detain people who are just charged with a crime. And the reason I brought up Mr. Massey's bill from last time is because we know that people are charged unjustly all the time. We know that that happens, and we need to be really sure that we're protecting due process for everybody. And I care about due process for everybody regardless of legal status. I care about due process for the people that are here in this country, making sure that we have the ability for people to go through that process. And so all my amendment does is say, let's make sure we at least have due process for people who are charged with or arrested for, but not yet haven't gone through the process, don't have a conviction, haven't admitted to having convicted. I don't touch any of that that's in your bill, Mr. Chairman. I literally just have an amendment saying if you're charged with or arrested with, you should not be mandatorily detained because you haven't gone through the legal due process that you are due for. So that is what my amendment is, and I reject the assertion that somehow Democrats want to not adhere even to what is current law or want to allow everybody. No, we just want people to have due process, and what your bill does is expand dramatically and hurt the due process rights, including, by the way, of legal residents who are here, people who are on TPS, people who are DACA recipients, people who have the legal ability to be here. This is a real problem, and I think everybody, including on the other side, if you believe in due process, you should want to support this amendment. I yield back to the gentlelady from Pennsylvania.
Thank you, and I yield back.
Gentlelady yields back. Is there further discussion? Mr. Biggs.